Good afternoon. This is Janice Strutt with Morgan's Caring Connection, and today's empowerment session topic is what is an estate planning attorney? We're joined today by Liam Gilhooly from LFG Legal, LLC, and we're going to cover some of the basics around what an estate planning attorney is, and we'll elaborate, I'm sure, in more depth in some upcoming sessions. But without further ado, we'll go ahead and get started. Thanks for joining me today, Liam.
Thank you, Janice.
You bet.
Pleasure to be.
So, I don't know. I guess let's get right down to it. Like what is an estate planning attorney? Because a lot of people evidently don't know, and they don't know when the right thing to hire you for and all that good stuff. So I'll let you go into that.
Right. So estate planning attorneys, it's a very broad role. I would say it's more like a family lawyer than most other lawyer roles in terms of, what kind of area they specialize in, just because, estate planning, that is a very big umbrella. Under that, you have all your family planning, who, what is your plan around disability? What is your plan around, getting assets to the next generation? How do you want to manage the items in your marriage? What kind of, who do you want to nominate for your healthcare, financial powers of attorney? It can be a very big role within a family. And that isn't necessarily true for all areas of the law. So, and we are some of us are limited in what we do. So, estate planning is one area that is a big area. But, if you had a issue, if a client had an issue with divorce, well, then I wouldn't take that on myself. I would hand that over to another attorney, and the same is true for other areas of the law. So I like to think of estate planning attorneys as connectors, a good kind of liaison to go to in order to get to solve your issues in the legal sphere. So let's focus more so on what estate planners actually do. So, I mean, we specialize in helping families in two main areas. So wealth transfer, and overall family planning. So we guide clients through the primary methods of transferring assets after their death. And that is really through either probate and wills, beneficiary designations, and or trust planning. So that means, do you want to go through probate? What does that entail? Giving the client the full sense of the picture in terms of what exactly the family will be going through after they pass away, and what types of things they'll need to do in order to make sure everything is, squared off. And really, I think the goal of a good estate planning attorney is to educate the clients on how these options work and offer tailored advice to ensure that inheritance benefit rather than burden the family. And that can especially be true with special needs families, as we know.
Mm-hmm.
So, just focusing on probate and wills right now, the threshold for a probate triggering in Wisconsin is if the person's estate is $50,000 or higher. Now, you can lower that threshold by attaching beneficiary designations or transfer on death deeds to your biggest assets, getting those assets directly to the named individuals rather than having to rely on the probate process, the probate court, to do that. And that's a good plan, but there are holes in that I personally don't like, and a lot of families don't appreciate either. I mean, what happens if a beneficiary that you named on your beneficiary form predeceases you? Well, there's only so much that you can put on a beneficiary designation form. And, that type of thing can be resolved pretty easily by having a trust plan in place that is a much more comprehensive document and covers a wider array of situations and, contingencies that could go wrong in an estate plan. So that brings me to trust planning. So a common, reliable approach to avoiding probate using trust planning is using a revocable living trust. Now, that revocable living trust will hold assets while you're alive, and it provides a plan for managing assets in the case of your disability, a child's disability, and it allows, trusted individuals that you name while you are, you know, fully alive and breathing and thinking well, to act on your behalf when you can't do that anymore. And then once you pass away, those assets are passed down to those named individuals or other individuals that you'll name in the trust, in accordance with your wishes. And
Mhm.
you can do that, minimizing taxes and fees and time spent in relative to probate as well.
Right. Absolutely. That makes total sense. And what I think a lot of people don't understand is although that this is the beginning and the foundation, it becomes kind of a living, breathing thing in that as things in your life change, your circumstances change, it needs to be revisited. And but most importantly, you get to decide. Like
Mhm.
you're not leaving it up to the courts to decide. You get to decide how things are going to be after you can no longer make those decisions. So I think that that's what a lot of people just really kind of don't understand. We just know that in a lot of cases, people just know that probate isn't something they want to have happen. I don't think they really understand why they don't want it to happen or how do they avoid that from happening. And that's why when people come into an attorney's office and they just say, "Oh, a will is fine. A will is all I need," because they're looking at a cost standpoint, more cases than not,
Mhm.
or they're just maybe overall kind of misinformed that a will isn't all they need. So I appreciate when you have someone like yourself, and I'll use the word loosely just to be safe, but you have an area of specialty of law. So I'm not going to say that you're the end all be all, but versus a general practice attorney, you focus your efforts in this area of expertise. And so you can flow through all the ever-changing needs that families like ours have. And I
Right.
think that that's what a lot of people just don't understand. Or they're under the total misconception that the only time you talk to an estate planning attorney is if you are wealthy and,
Yep. That is a
like
very common.
high net worth. Well, that's not the case. I mean, we all have money at some level, no matter what it is. And it's just a matter of where do you want that money to go when you're no longer alive?
Mhm.
And do you want to be the one making the decisions around it? Is really the bottom line.
Right.
And I think we've talked about it before that although it's not inexpensive, I don't know, if I do my estate plan in my 40s and I live to be 90 and I've spent, and I'm just going to throw out a number. By no means is it what it is for anybody necessarily, but just for easy numbers, $10,000. Well, $10,000 over 60 years or 50 years comes out to be pennies. So we have to look at the overall return on investment of making those decisions ourselves. And then not only that, not leaving the burden to somebody else to have to make those decisions.
Right.
So that's one of the reasons why I think it's so important for people to really understand what an estate planning attorney is and when to come and see you and what for.
Yep.
Um,
And just to be clear, with wills and probate, you can still decide where your assets go using a will. It will just have to be through the probate court then.
right.
Uh, and
Which could
and
take years.
exactly, the negatives to that are it's very costly because instead of paying a flat fee to an estate planning attorney, to get your assets tied up while you're alive and get them where you want to go, you're going to be paying a hourly rate to a probate attorney, which is an indefinite amount of time because the probate proceeding could get, thrown into a traffic jam for any number of reasons, including familial conflict,
Mhm.
which a lot of people don't like to see.
Well, and the
Um,
thing is, when you say you, it's not me because now
right.
I'm deceased. You're leaving that financial burden to the people that you're leaving the money behind to.
Mhm.
So
Yep.
if you don't have per se a lot of money in the first place, is that how you want your money to be spent? Is kind of the question,
Right.
or do you want to make sure that no matter what the amount of money is, that it does go to the people you designate and you're not tying those funds in up in other expenses.
Right. And then there's also tax considerations like the estate tax and capital gains taxes. Those are both very important parts of an estate plan that we want to maximize the exemptions and minimize the actual taxes, the tax burden.
Hmm.
With the estate tax, you could say right now, well, the estate tax is so high that, we will never have to worry about it. Well, that's not necessarily true. It is $13.6 million right now per individual in 2024, but that's not to say that it will remain that high forever.
Right,
In the 2000, the estate tax exemption was only $650,000. So that was a much, much lower threshold compared to now. And, depending on where the, legislature goes as far as the federal legislature and Congress, they could redo the estate tax exemption and the capital gains taxes structure to increase taxes and lower the benefits that you can get by getting your estate plan done. So it's important to plan around these numbers, not just in the here and now, but also considering what could happen in the future and allow for greater flexibility in the plan.
right.
Um, and just another thing is that, both wills and trusts are, just components of a comprehensive estate plan.
Right.
You know, that's just one document that gets your assets to where they need to go next in the event of death or disability in the case of a trust, and just in the event of death in the case of a will. But as a part of that overall comprehensive estate plan, there should be included those healthcare and financial powers of attorney in case of disability, memorial instructions, so that when, you know, when you pass away, that your, son or daughter who you want to, be your personal representative and give your eulogy will know exactly how you'd like to be remembered by. And so it's much more than just the legal interaction. There's more, and there is a overall family planning piece to this as well, that comes into the picture, and I don't undervalue that at all. I think
Well, I often tell people that, we often, meaning families with special needs dependents, avoid this, not because we don't, well, we don't want to do it. Let's just call it what it is. You're absolutely right. We're making a lot of decisions, and that's hard. And some are unknown, which is okay. I tell people often that part of estate planning is your wishes upon death, like burial, etc. And we did our estate plan, our trust 10 years ago the first time. And I didn't know what I wanted. And until somebody said something to me that triggered me, and I went, oh, yeah, that's it. That's the answer for me. And now
Mhm.
it's in my trust. My wife, on the other hand, still hasn't made any decisions. You
Mm.
know, so there may be things, but at least if it gets the thought process going,
Right. And that's the beauty of it, is that, you established your trust 10 years ago. Now, if you go back to that estate planning attorney, she's not going to charge you that full, $4,000 or whatever it is to have it redone.
right,
It's going to be a very minor tweak, and it's going to be a minor fee accordingly.
right,
So, it is sort of an investment, as you were saying earlier, to make sure that you have a plan going forward, not only for when you pass away, because we never know when we're going to pass away. It really is every day. There's a chance that you might not make it till tomorrow, and
right.
it's an unfortunate reality in life. But making sure that you have a plan to deal with that, no matter what happens, that's really the value of having a strong estate plan in place. Is
Absolutely.
is
I think a lot of people just hear wills and trusts, so that becomes a familiarity to them. However, one of the things that is actually next to talk about is special needs trusts. Like, what do you do when you have a special needs dependent? Because and I don't want to go too in the weeds. I honestly feel like we could do another session just about this alone, because we know that there are lots of options, not just one. And it, again, like everything else, depends on your situation. So, but I think it's important to at least address, what do you do in a case where you have a special needs dependent?
Right. So, I mean, trust planning can provide a lot of protections for special needs dependents, particularly in regard to maintaining their government benefits and assistance through SSI and Medicaid benefits. So let's just, keep it at a very high view, like you said. Every trust, no matter whether it's a special needs trust, a revocable living trust, an irrevocable trust, whatever it is, every trust has three parties involved to that system. Okay, there's the grantor, the person who's making the trust. There's the trustee, the person who manages the trust, and then there's the beneficiary, the person who the trust is for, who's going to receive distributions from that trust. Now, in a special needs trust, normally what would happen, what I often see is mom and dad will be the grantors. They will also be the trustees during their lifetime. And then the beneficiary will be their special needs dependent, who they can manage their funds for, put money into that special needs trust account titled into the name of the trust, and make distributions for specific items to the special needs dependent, and have those items not be, or those purchases or any money inside of the trust count against them for their government benefits. Because like you and I know, you can only be at or below $2,000 worth of overall assets to maintain your SSI and Medicaid eligibility. So
Right.
once you pass that, SSI and Medicaid, they could kick you off of their benefits, not you, but the child, obviously. And then it's a whole process to requalify and get those benefits back before, you know, life can return as normal. So by establishing a special needs trust under your overall estate plan as mom or dad, you can name under your will or a trust to create a special needs trust for that dependent, making sure that no matter what happens, if you or your spouse pass away, then that there's always a receptacle to receive that money or those assets without jeopardizing those benefits that child might be relying on.
I think, this is so important, but it's also important for people to give the perspective and talk about our parents, their grandparents. Because, I've heard so many times, oh, grandma thought she was doing the right thing and she left my child an inheritance
Right.
and now what? And I don't want people to panic when something like that happens. It's not ideal by any means, but if I understand correctly, I'm not giving any legal advice, but it's not the end of the world. There
No,
are things that can be put in place so that that gets sheltered and protects them, from having their money jeopardized, their funds jeopardized.
right.
But nonetheless, then that's just one more hoop that we have to jump through.
At the centerpiece of that all is really coordination and communication. You don't want grandma or grandpa leaving money to the special needs child without speaking a word about it. You want there to be communication between the parent and the grandparents so that they know if there is a special needs trust in place, that instead of naming that child individually, they name their special needs trust instead. And like you said, it's not the end of the world if they're the grandparents name the child, the special needs dependent individually. That child can reject that distribution or that inheritance, and it'll basically kick back up to the parents.
Mhm.
But that's not what they wanted to have happen, because then, it could go to each of not the grandchildren, but the children in equal shares, and that may not have been what the grandparents wanted to begin with.
Right.
And, so it could be the best way to, get a sense of what kind of planning is out there beforehand, speak to an estate planning attorney, get a sense of the picture, and, maybe create a revocable living trust or have a will that sets up a special needs trust at your passing or during your lifetime, so that you can have that bucket. I like to think of it as a bucket or a receptacle, so that those funds can cleanly transfer into that child's estate, and for the benefit of the special needs child, without, like we were saying, jeopardizing their benefits.
Right. Well, this all makes total sense to me. And I'm going to go back to what we said a little while ago, that there's this preconceived notion, I think, from a lot of people that I even had was, I can't, I don't, why would I contact an estate planning attorney? I don't have any money. I'm not wealthy, you know? I think that, again, this is a big misconception. It's not about your net worth. It's about protecting what you do have, period. And again, making sure that it's going where you want it to go, how you want it to go there. And the other thing, a lot of people, you know, today more than ever, I don't want to quote statistics, but we all know that divorce, blended families, this, that, and the other are, you know, there's so many different situations out there right now that, you know, some parents are on second marriages, so they may have some biological children separate. They may have some biological children together. They
Mhm.
may have their finances separate from one another. I mean, like, there's so many varieties of things that it's super important to sit down with somebody who can coach us through how to set things up correctly. So again, that nobody ends up in a financial situation, or just overall, I'll just call it what it is. It's a burden. So let's keep things from being a burden. Let's have these conversations. So, you know, to that point, we agree you don't have to be wealthy. So let's talk about that a little bit.
Right. You don't have to be wealthy. I mean, as I just mentioned, it's a $2,000 asset threshold to be kicked off of these benefits. So I don't know anybody in the world, well, maybe anybody in the United States who would consider $2,000 to be wealthy, right? So that's all you need to do is pass down $2,000 to your child to your special needs dependent to jeopardize their benefits. So that is, if you have above that amount, then you should probably consider having something in place to make sure that that doesn't happen. So yeah, I mean, yeah, working with an estate planning attorney, you don't need to be wealthy. Everybody should have an estate plan. And that's just not, I'm not just saying that because I'm an estate planning attorney. I say that because it's true. Everybody should have an estate plan. I mean, from personal experience, more than 90% of my clients who I see, you know, they come to me with a bad probate experience. They come to me because, you know, they're either their friend or their grandma or their grandpa or their mom or dad just passed away, and there was a terrible probate that commenced, and it lasted for way longer than they expected. There was a lot, there was a lot less done than they expected, and it was just it was a terrible mess.
Mhm.
So I think
We're
the
trying
one
to
of
avoid that.
exactly. So one of the central benefits of working with an estate planning attorney or working in this field is that a lot of us, we don't charge hourly rates. You know, we'll operate under fixed fees, giving, you know, in the case of my firm, LFG Legal, we focus on education first and foremost. So I always meet with clients, give them a prospective clients, give them a better sense of the picture through an educational estate planning meeting first. That's completely complimentary. And then, you know, the next meetings will dive deeper into their particular situation and how an estate plan could benefit them. And then I give them a flat fee quote on what those kinds of services would cost, and then they can choose to proceed from there. I'm not going to bill them hourly for my time. I have the utmost confidence that once families have a good sense of the picture of what is out there and what will happen once they pass away, that they'll want to do this work.
Right,
It's a no-brainer.
right.
A lot of other families. So
And I believe you're, and a lot of other state attorneys, I believe, do this. It's typically here's a packet, you know, like, start going and doing your homework, because it's not that cut and dry. And in a lot of cases, there's conversations that have to take place in order to get the answers that you need. So I try
exactly.
to tell a lot of people, and correct me if I'm wrong, but I'm going to say that average estate plan from date of contact with the estate planning attorney to signing paperwork can be anywhere from 3 to 6 months.
That is pretty normal, I would say.
Yeah.
Yeah.
Yeah. Because again, like, if you're making decisions about beneficiaries, you're making decisions about who are going to raise my children, who, you know, where is my special needs dependent going to live? I mean, like, there's a lot of things that go into this. And I tell people, with I try to just be 100% transparent. This is probably the hardest thing that you're going to do. But when it's done and over with, and you have that binder that is ridiculously thick, it gives that sense of stability, security. You can breathe a little bit easier, knowing that at least if nothing else, now you have a plan in place. And again, I'll say it again that you probably won't know all the answers. And at once the main document is done, the work in some cases does continue, and that's okay. You don't
Mhm.
have to have all the answers, but a good financial plan and having it in place, and then being able to come back and revisit it, whether it's 6 months, a year, whatever later, it's fine. It's okay. I don't think you guys expect us to have all the answers in order to complete things. Am I
Mhm.
correct in that?
No, without a doubt. And I will say, as far as the time required or the time frame in getting these plans done, it really is dependent on, a few things. I mean, it's dependent on the client's schedule, how often and when they can meet, the attorney's schedule, how often they can meet, what their workload is. And then it's also reliant on, how much time the clients need to think of these positions to nominate people. For some people, it's very fast. They know immediately
Yeah.
who I trust, who I want to kind of take the reins after I can't anymore. And for others, it takes a lot longer to think of those things because they're either important decisions or maybe they don't have as many trusted individuals that they can rely on. And so it really is a situation by situation, um, you know, thing. And, for some families, you can get this process done in 2 months. For others, it takes six.
Yeah.
So it's different for everybody. But at the end of the day, like you said, it is very worth it to get it done.
And not to go off the rails too much, and then we're going to wrap up, but there I do hear from a lot of families, I don't have anybody else to turn to. So I know, based on my experience with you directly, I'm just going to say there are other options. We can point people in directions where there are other options for them to get that support that they need.
Mhm.
Am I incorrect in saying that?
Right. If you don't have anybody that you trust to really carry out your wishes, is that what you're getting at?
Or family, or there are
Yeah, if you
people
don't
that
have
they're
anybody.
like, I'm all I have, this is
Right.
it, so then what?
Well, then there are third-party trust companies or fiduciary companies that will actually administer your estate for you and make sure that everything is done, from a professional point of view and from an estate administration point of view. But those services can sometimes be expensive, and if we can, normally we'd like to avoid them, but in some cases it's necessary.
Right.
And I know that some companies are more flexible than others and what kind of work they'll take on. So that's always a conversation to have if no names are, top of mind for that kind
Yeah,
of
I
thing.
just don't want people to think like, okay, well, what if I don't, then I have no other options. I just wanted to put it out there that that's not the case. There
Right.
are options. It just is based on your experience, how we figure out what the next steps are. So don't make that a determination factor that, oh, well, then I guess I just can't do my estate planning.
Yeah.
There
Yeah.
are
No,
other options.
without a doubt.
Okay.
Yes.
Wonderful. Well, I appreciate your time today. I look forward to breaking these down into some more sessions here in the next upcoming months. And of course, if anybody has any further questions, they can reach out to me at Morgan's Caring Connection or with Liam. The information will be on the screen at the end of the video. So please feel free to reach out to either one of us. Also, if anybody has any other topics of conversation that they're challenged with, can't find answers to, please also let us know about that so we can continue to provide these videos, these empowerment sessions to you so that they're beneficial for you, because that's why we're doing this. So thanks so much. I appreciate your time and have a wonderful day.
Thanks, Janice.